Good morning, America. Hubert Johnson here with Taxes Made Easy. Just welcome you to another Friday here in Tucson. It's a little rainy today, which is an exception. But there's a lot of news out there today. We had the State of the Union last night. Didn't really touch too much on taxes, and we're not going to spend a lot of time on that. But there's definitely news to be covered. But we're going to focus today on 1099 versus W-2 employees. And so we've mentioned this, we've talked about this, but we're going to do a deep dive today and try to answer your questions about what is the difference between the two. How should you be qualifying your employees, or how should you be qualified as an employee, and what's going on with and how to with the politics of it and the changing landscape that businesses are facing. So we'll be back after a short break, and thank you again for watching. Welcome back, everybody. This is Hubert Johnson again with Guardian Tax Law on Taxes Made Easy on the Smart Money channel or smartmoneyculture.tv. I want to thank everybody that's watching either live or on rebroadcast. And today we're going to be focusing on a topic that affects pretty much everybody. Most workers, should you be classified as a 1099 or a W-2? And well, it does deal with politics. I'm going to refrain from commenting on the politics of just explaining how this affects businesses and how this is a real issue out there today, currently being litigated. Before we dive into that, just want to touch on the IRS news for the day. This is put out yesterday that the IRS has special hours on March 16th for face-to-face help at 70 taxpayer centers across the country. So if you can't get help, you're frustrated, again, make an appointment or try to walk in. These are taxpayer assistance centers across the country. So there's 70 of them. You can try to get in there and talk to someone face to face. You can also use it and talk to someone in person, and you can schedule an appointment to do so Monday through Friday with the IRS. The appointment times are now months out. But if you have an authority issue that you just can't get resolved, that's something I've used for my clients, where you can make that appointment, actually go down and sit down with somebody. And do you need a representative there? No, but it can be handy to have someone that speaks Irish language and kind of really cut through and get to the heart of the matter and help resolve your case for you. But again, if you have those issues, you can look at this article that's up for face-to-face centers on March 16th. And again, they have special Saturday hours for those that are struggling to get in and see somebody. So last night, I'm not going to dwell on it, but again, they had the State of the Union. If you didn't watch it, you're in good company, because I didn't either. It doesn't matter which party it is. It's all one-sided. There's and I don't really enjoy that myself. So some of the things that are out there, and that's what I was watching for, was there anything about the budget? Was there anything about progress on some key issues that are, again, facing the nation? And when it comes to taxes and budgeting for the country, I didn't really hear much. I don't think there's a lot of disagreement right now between Republicans and Democrats, even though we have a shutdown looming, and that was supposed to start today. The House of Representatives signed off on it with bipartisan support. So about 100 Republicans didn't sign on to it, but everybody else did, and that sailed through the Senate and was signed by President Biden. And then in 2 weeks, the rest of it will probably be passed in the same manner. It's election season. Nobody wants to shut down the government, especially right in the middle of tax time. And so that can is getting kicked down the road. Whether or not that's a good thing is a different story. We're not going to get into that. So speaking about the news, I'm just going to do a broad overview before we get into the nitty gritty of this 1099 versus W-2 employee issue. And how do you tell if you're a 1099 employee? It's simple. Nobody's taking Social Security taxes or Medicare taxes out of your paycheck. That's the biggest way to tell. If someone can be taking taxes out, they can be taking for health insurance, other things out of your check. But if they're taking Social Security and Medicare out, you're a W-2 employee. That's the easiest way to tell. What's the main difference between 1099 and W-2? 1099s are for part-time employees, gig work, someone that's hired to do a specific job. And that definition has become a lot more narrow with the current administration and also in many states. So the general trend is to really push things towards categorizing most people as W-2 employees. Why? Because if you're a W-2 employee, the government mandates that you have to take out for Social Security, Medicare, and FICA taxes, so your federal and state withholdings. And the government loves that because they'd much rather have that responsibility be on a much smaller number of business owners than all the employees. If the employees had to deal with the headache as a result of these laws, income tax would be a lot less popular. So it's a way to pass the buck and have someone else deal with it rather than the individual employees. So and there's all kinds of people that historically have been 1099 employees that want to stay that way. So people that, you have a lot of writers, you have a lot of screenplay writers in California. That's been one of the big issues here. You have a lot of delivery people. You have people that kind of run their own little thing. I've known people that own their own dump truck, and they made a living operating either a dump truck or a semi. They were had the freedom and flexibility of being self-employed without someone telling them what to do, where to be, etc. But that's changing. It's a changing landscape right now, and it's not just happening federally; it's happening in the states. So one of the big places it's changed is California. California is leading the charge on this. So like it or not, California has passed some major changes, and a lot of other states have adopted those states. So here in Arizona, we have a Democrat governor now, and their Department of Labor has adopted a lot of the same or similar rules to California. So essentially, and then the Biden administration adopted these same rules as well. So jumping to January 9th, 2024, they issued another rule that could curb gig work and contracting. This is from an article in Reuters. So this is just 2 months ago. Well, Ken and Pratt trucking, healthcare, and the idea is it's pushing people towards being that W-2 employee. Again, it's easier for the government, but it's not for businesses. And so they simplified the rule. Instead of an 8-part test that was more subjective, they made it a 3-part test, and there's a lot fewer exceptions. There's not nearly as much wiggle room, and things are definitely interpreted in a way that a lot more people are getting classified as W-2 employees. So on that same note, Uber in California has been a big case ever since California first started, changing their rules and laws on this. They felt like they were unfairly targeted and singled out. They fought this through the California courts and got denied. And now, currently, they're fighting this through the Ninth Circuit Court of Appeals. So the last update was December 18th of 2023, where Uber will win a rehearing with the 11 judges, so a full en banc rehearing of their case, claiming that they were unfairly singled out. And again, politicians are famous for this, where they exempt people that donate to them. Again, it happens both sides of the aisle. But again, Uber feels like they were kind of singled out and targeted. So Uber, Lyft, a lot of these drive share businesses, and this is happening in New York as well, where they've essentially destroyed the cab industry. Destroyed, replaced it, depending on your opinion. And it's made it possible for a lot of people to make money, but a lot of people are arguing, hey, Uber isn't paying people hardly anything. And depending on gas prices, that can be very true. As gas prices go up, the drivers eat the cost of that. So watch out for what's still happening. This might go to the Supreme Court, it might not. But again, changing rules, and most of this is being done administratively. California, they passed a law. And it's interesting that the Biden administration reversed the Trump era rule just a few months ago, because depending on what happens with the election, it might go back. And that's the frustrating thing. The worst thing for an economy is uncertainty. So people need to know what to expect so that they can plan for it accordingly, and then they can adjust their business model and make sure they're making a profit based on the rules that they have. So when the rules are constantly changing, it makes it harder for everybody. So that's why, and this is a little bit of politics in here, all of these executive decisions and rules being made by agencies rather than being passed by legislation does not help for certainty. They just get changed by the next administration, and then people don't know what to do. They don't know what to follow. So again, I'm laying the blame for this mainly on legislatures for not acting, not passing clear-cut rules that businesses and individuals can follow. So it's much harder to find wiggle room around actual past legislation rather than, and if they don't like what the government's doing or the executive, they need to lay it out and pass a statute, and then the courts will follow that statute. So it's really the primacy of law. It's where Congress speaks, it has priority. The executive is supposed to carry out what Congress has done, and the executive branch has a lot of latitude in deciding that. But the courts will absolutely follow the statutes over the executive branch's interpretation of that statute. So that's a lot of the news. There's a lot of new news on this on W-2 versus 1099. We're coming up on another break, but we're going to really dive into the meat of this. What is a 1099 versus W-2 employee, and how should they be classified? So again, stay with us, and this is very important because we are seeing people getting targeted by the Department of Labor, and it only takes one employee to complain or to request benefits for the government to scrutinize and say, hey, these people are being misclassified, and there's some pretty nasty penalties when it comes to this. So we'll be back shortly. Welcome back, everybody. We're focusing today on 1099 versus W-2 employees. How should you be classified, and how does this issue actually come up? And we're going to talk about towards the end how that actually comes up to business owners. And again, it's pretty nasty if the IRS gets in there. So what is the current law? The current law is there's 3 different things that you have to look at. So again, this is per the new regulations put out by the Biden administration a few months ago. So first of all, behavioral. I'm just going to kind of read through these because these are important, kind of give you the idea of what they're looking for. So this is, it used to be like a 14-part test. And so it was kind of a gray area in there, and there was some latitude. A lot of that latitude is gone now. So does a company control how the worker does the job? The more things you control, such as worker schedule, location, which tools they use, the methods they use to complete the task, the more likely they are to be classified as employee. Financial. Does a company control business aspects of the worker's job, such as how they're paid, whether they can seek other work in the market. If the answer is yes, it's more likely the worker should be considered an employee than a contractor. I think they said that right. What it means here is, does the company control business aspects of the job, such as, yes, you're going to pay them for the work they're done, but do you have a contract in place? Is it per job or is it ongoing work? Do they work with you or do they work with multiple other businesses? Is it really their own business? Do they advertise? Because here's the thing, though. What's happened is that a lot of things, people's traditional understanding of what a 1099 worker is not what the government is looking at. So there's a lot of positions where people are like, oh, that's an independent contractor. They're just working here part-time. No, you've got to be careful with this because the penalties are very strict, but they're really looking at someone that owns and operates a business and they work for you some of the time. It can be ongoing work, but it needs to be for per piecemeal, per job. And again, to protect yourself, the question is, are they independent? Do they have their own profit and loss? Do they have any risk here? Do they have any business expenses? This is what they're looking at. Are there any benefits provided? The more benefits provided, the less likely it should be an independent contractor. Are they paid? Do they have any insurance? Paid time off? Is the job expected to last indefinitely? And then are there keys? This is a funny one. Are the services provided a key aspect of the business? So the more integral or important that this work is to the business, the more likely they're going to say you should classify them as an employee. And again, that is a very hard thing. I mean, of course, if you didn't need the work done, you wouldn't hire them. So you go to your classical independent contractor where you have a general contractor, and then he hires all kinds of subcontractors. Each subcontractor has their own business. They come and they do a job, and they're paid for doing the job, and they leave. They don't. The contractor doesn't care as long as they get the job done on time. They don't care how they do their job. They don't care who they bring to do the job. They don't really care if the subcontractor brings other people to do the job. The subcontractor is responsible for the job. Get the work done. Now, on the flip side of this, there are plenty of professionals that are definitely not employees. So if you have an attorney that you consult with regularly, or a CPA that handles your books, or a bookkeeper that does the bookkeeping for your firm, you can have an internal bookkeeper. But if you have someone that has their own business, you know that they have other clients, and they run their business independent of you, then that would be someone that's going to be termed an independent contractor, and you'll save treating them as such. So there's a lot of people that are comfortable and happy being independent contractors that are losing that classification and not very happy with it. But again, freelance writers who work on an assignment basis rather than set hours, and these are just some of the examples here. Consultants have a clear start and end date, and then gig workers who come, they perform a job, or they do something, then they leave. Freelance designers, developers, they work on an assignment or project basis. They do the work, they're done, and there's no expectation that they will continue to work. Again, can some of these people, if be considered a W-2 employee? Absolutely. So there's no hard and fast line. The closer you are to that line, I would err on the side of caution and treat somebody as a W-2 employee. Staff writers with scheduled hours. So if they have scheduled hours, if you tell them where to be, if you know when they're coming and going, project managers with ongoing work and standing to meetings. err on the side of caution of labeling them as employees, because you don't want to get burned by this. And again, I'm going to say that multiple times. It's not comprehensive, but this is where the government is going. These rules that I went over, behavioral, financial, type of relationship, those are the 3 standards put out by the government. And they are not going to be interpreted in favor of business owners. So take that with a grain of salt. Consider that when you're looking at this, if they could be an employee, treat them as an employee. And even though it might not make sense to you, but this is where the government is going. For example, true story, I have a business right now that's still in with the Department of Labor here in Arizona. They have employees that come and go. They'll have set times where they come in and they take care of a client, but they choose when they're going to work. They leave when they want to. They come when they want to. They bring some of their own materials. But because they don't have a traditional business model where they have their own profit and loss statement, they don't have any risk of loss. So if someone has a business and things go sour, or if their expenses are too high, they can lose money. That's what the IRS is looking for in an independent contractor. Someone who has their own separate business, has worked for multiple different companies, and once the job is done, they're typically done and they move on. There are exceptions to that, but again, where this is going is towards classifying people as employees, a W-2 employee. So again, it's if this was an easy area, and this change, I don't think it helped people, because it took the typical understanding where there's some gray area, there's some give and take, and they chucked it out the window. And so now consider this: if anybody, if they don't have their own business, if they're not a professional, if they have a professional license, it's more likely that they can be treated as a 1099 employee. If that relationship becomes more consistent over time, you might need to start paying them as a W-2 employee. So the nature of a relationship can change. And so that's why you have to be very careful for this with these classifications. So kind of a clear definition, and this is straight from Forbes. Contractors are self-employed workers selling you a service, while employees work for the benefit of and under the rule of your business. So if someone's coming and saying, hey, I can do this for you, these are my fees, this is the expectation of what I'm going to do, you're pretty safe treating them as an independent contractor, especially if they do that work for multiple locations. Classic example is marketing firms. So if you're paying them a fixed fee, you don't know how many hours they're working, but you know what they're supposed to be doing. They're supposed to do a job, and you're paying them a fixed fee to do that job. That is classic 1099 or independent contractor. Who's responsible for doing the 1099s and W-2s? You are. So again, be aware that, again, there's a lot of penalties for not filing the W-2s correctly. If you are not sure how to do this, talk to a payroll professional. A good CPA or payroll company can get these forms filed for you, and there's some pretty hefty penalties for not getting those filed. One company, and they had about 20 employees. They had a tax year that was wasn't done. Someone had made a mistake. There was a snafu there, and they got with a $360,000 penalty. Now we were able to get that reduced and back out that entire penalty, but it took years of negotiation and work on that case. And when we finally wrapped it up, they were very happy, but it took a lot of time and effort in negotiating with the IRS, with the state, to make sure this was all corrected. So when you do a W-2, that goes to the Social Security Administration, it goes to the IRS, and that's what people use to file their taxes. It is very important to do these correctly. There are plenty of times where people get burned, and I see cases all the time where these are not done correctly, and now you have an issue with your employee. So if there's a mistake and multiple W-2s are issued, or the incorrect income is issued, what you're submitting to the IRS will be used on their tax returns. And if it's not correct, they'll get hit with underreporting penalties. They'll get hit with all kinds of tax issues. So it's a great way to burn an employee or hurt somebody by not filing this information correctly. 1099 just goes straight to the IRS and to the independent contractor. Again, same filing deadline for both, January 31st. And so just make sure that you're following these steps, that you're doing this properly. So again, any questions you might have about this, talk to a professional, but keep in mind, this is a changing landscape. So as California has gone to the extreme, and you might think that, okay, I'm going to classify them this way, I'm going to be good moving forward. You need to stay on top of the changes in the law here, because the sand can move underneath your feet. And if it gets to the point that, yeah, you should consider filing or classifying employees as W-2, it'll save you a lot of heartache. It's going to be more expensive. It's estimated that having W-2s employees rather than 1099s is about 30% more expensive for the business. So it makes labor more expensive, more involved. But again, that's the government wanting to put that burden on employers, so that the taxes are paid, that they get all the FICA. The withholding is all based on the employer rather than the employee. And so there are obvious considerations here. It is more expensive, but it's going to be cheaper than having the government come after you. So how does this even trigger? How does this even come to the government's attention? One of the big issues is during the pandemic. People ask for unemployment. People ask for help from the government, assistance from the government. Someone asked for the PUA, saying, hey, I'm an independent contractor. And the government looked at him and said, we don't think you are. You should have been a W-2 employee, and we're going to treat you back like that and go back and look at not only that, just that employee, but all the employees. It only takes one complaint from an employee to the labor board to trigger an audit. So how do you go through this audit? Again, these are some of the things that trigger it. So a complaint, someone asks for benefits, they can just do an audit of your business. When an auditor from the Department of Labor comes to your business, take this seriously. Contact an employment attorney as soon as you can, because you don't want to say anything to this auditor. What you say can and will be used against you, even if you don't understand what's going on. It used to be that you could have a conversation with people and kind of talk things out. The way businesses are being treated now, they're being treated as guilty. And again, depends on the state, but in the cases I've seen, they're being treated as guilty until proven innocent. So words have been taken out of context when they didn't understand the meaning of the words. And I don't expect them to do a good job. Do not expect them to give you a fair shake on this. This is not something we normally do. So this is not something I'm saying, hey, come and call us, hire us. If you have questions, we'll try to steer you in the right direction. But again, be very careful who you talk to. Get their name, get their information. Say, let me get some representation. You're always entitled to representation when dealing with the government. In almost all cases, again, I throw that caveat up, but you almost always have the right to representation. before you share information, before you do an interview, and again, you might not even know who this person is or really understand who they are, but giving information to the government can be very detrimental to you and to your business. So it definitely helps to get someone that understands what's going on and can represent you or give you advice on the right way of doing this. You do have appeal rights, but it's always better to deal with this up front and deal with this directly. So does the government understand that they're changing the rules, so to speak? Yes. Are they very sympathetic? No. No, they're not. The cases I've seen in general, they're not sympathetic. They're not understanding. They're going to assume that you know that you knew that you should have been treating your employees differently this whole time and that you were mistreating your employees. That's the general attitude that I've seen from the Department of Labor. Again, it's unfortunately, they normally, most of them have never run a business. They've never operated a business. Most people haven't. They don't understand what business owners go through. Now, are there business owners that, are there times I've told people, hey, report, if this is the situation, if this is the truth, go report it to the Department of Labor? Absolutely. When the employer is not paying their person, they're not, they're shortchanging them, the pay stubs say one thing, but they're actually getting paid something else. Absolutely. There's a lot of teeth if you go to the Department of Labor and they pick up the case. And there's a lot of penalties. So as employers, make sure you're on the up and up and doing everything right. But especially when it comes to this 1099 issue, if someone comes knocking, get representation first. Ask questions, don't answer questions. Who are you? Where are you from? How do I get a hold of you? What's your contact information? Let me get back to you. And then get back to them. The thing is, you can always say, let me get back to you. Let me get some more information. But the key is to actually get back to them. Don't ignore this. It's not going to get away. It's not going to go away. And this is a growing issue. This is another moneymaker for the government now, and they're in many states. And they're pushing people and they're pushing businesses towards this W-2 classification. So how do you deal with this? That's what I want to kind of focus on. When we come back, there are programs to address the penalties. Again, it can be as high as 20%. And we're going to touch on that when we come back. Again, thank you for watching live or on rebroadcast, and we'll be right back in just a few short minutes. Hubert Johnson here with Guardian Tax Laws, following up on wrapping up this section on 1099s versus W-2 employees. So this has not been in the most positive videos, to be honest. It's for most business owners, this is a very difficult thing to handle. And if you're an employee and you're not sure if you're being treated right, go talk to your employer first. Try to work with them first, because again, what happens when the Department of Labor, IRS, goes after employer is that often the businesses are shut down and everybody loses their job. I've got one company that we're working now with that we don't know if the business is going to stay open. If the penalties are too bad, the whole thing will get shut down. And this is an area that historically in their competition has been independent contractors. So the employers were acting on good faith. This is what the employees wanted, was to be treated as 1099 contractors, give them a lot of liberty, give them a lot of independence, and a lot of that's going to go away as this changes. So is there any relief here? Absolutely. So if you want to get a determination from the IRS, if you're not sure and you're out there as an employer, you can file a form SS8. And I'm going to do a quick screen share. and just kind of share the form. So again, you submit this form, and this shows good faith by the IRS saying, look, I have this person, I'm working for the firm's name, worker's name, general information, and you can just kind of describe, the time period. Do you think this is being completed by the firm or the worker? Do you think they should be 1099 employees? And it actually asks you, the number of workers, how did the job they go through, and attach copies of how you've been doing this, describe the work. Again, they're going to ask a lot of the questions as you go through this. And again, this is the general information. Then they go on behavioral control. These three factors with the change of law: financial control, relationship of the worker to the firm. So they're going to go in a lot more detail than what we covered. Again, it's really going to, do they own their own business or not? So just fill it out. There's no right or wrong answer here as you go through and fill it out as completely as possible, and the IRS will give you their opinion as to whether or not they should be 1099 or W-2. So this is a handy form to use. And you can submit this to the IRS, and they will give you their determination. Once you have their answer, and if they say 1099, then that's, if they come back later and change their mind, you can say, hey, I relied on this. This is a determination that the IRS made and gave me. So if they messed up, that's on the IRS. So that SS8 form is very handy. Another thing we're going to look at here is section 530. So I'm going to share my screen again. So here, this is directly from the IRS website, Worker Reclassification, Section 530, Relief. So if the Department of Labor, the IRS comes in and says, hey, you've been misclassifying your workers, there is some relief. First of all, you can get the penalties waived, given that you met one of three requirements. So first of all, reporting consistency. Have you been filing their 1099s? Have you been filing their W-2s? However you had them classified. Have you been consistent with substance? So it kind of explains it all down here. Have you been consistent on how you've been treating them? Has it been a substantially similar position throughout this period that you're asking for this relief? So if you're bouncing someone around and you're playing games with the system, I'm going to treat them as a 1099 now, W-2 later, they don't like that. And then reasonable basis is the third one. Did you have something that you were depending on? So if you get that SSA determination letter, can be very helpful. Again, if you had dealt through a prior audit, if there's judicial precedent or there's case law that is relevant to what you're talking about, similar facts, or industry practice. So again, if it's you're in an industry, it's what's typically done, it's what most people are doing, then that gives you a safe harbor. So you can say, look, I had a reasonable basis for classifying them as 1099 employees, and you can get most of the penalties waived. So again, this is very important to understand for employers, that if you do need to misclassify them, if you do get audited, it's not the end of the world. You can get rid of most of these damages. Now, do you have to apply for this? No. Hopefully, when you get audited or this actually gets considered, the IRS should automatically look at it. If they don't waive the penalties and interest, you should be raising this section 530 and saying, hey, I qualify for this and these are the reasons why. Be proactive and say, look, I need to have these waived and this is the reason for it. You can always ask for an abatement of penalties based on this section. So again, be proactive about this. If you do get caught in this situation, again, the rule is pretty straightforward. And then again, this goes into more who's covered by it, the burden of proof. The burden of proof is on the business. But just like any appeal, you have to follow through. You have to be consistent with it. And the more consistent that you have, the more likely that you're going to get this relief. So again, that's a very handy section there. So the world is not falling, not going to end if you do get audited or if you have to change. Now, how far back is the IRS going to go? 3 years. So you just have to look at the last 3 years to determine, and change the worker classification. So if you have questions, if you're not sure what to do or how to appeal, how to file for an abatement, either a good CPA that understands this, or this is something we can do and we deal with as a tax attorney working directly with the IRS. We deal with abatements and understand the difference between W-2 and 1099 employees. If you're initially trying to determine where you should be, go to an employment attorney. Use the SS8 form to get a determination from the IRS, and then you'll follow that accordingly. So one of the key things here is stay on top of the law. Stay on top of changes as they happen, because, like I said, this is changing law. There's a red state, blue state difference here. So depending on the state, depending on where you live, you could have different state laws. The federal law that just got put out is going to get challenged. It's going to get challenged in the courts. It's pretty new, but this is the law as it is, and it very well might stay that way. So if it does, be aware. Protect yourself, protect your business, and in essence, you're protecting your employees by by being on top of the latest laws, especially when it comes to their wages, but also making sure that it doesn't affect the business and you can preserve their jobs and employment. Even though as a 1099 employee, they more and more they don't want it's more, and they have their own business is how they're trying to classify it and get rid of pretty much most other independent contractors. Is this going to be a consistent struggle? Absolutely. How to treat employees, and again, the government, the more we go big brother, the more we go big government, they're going to want everything to fit their full mold. They want everybody to fit in certain square pegs, so to speak. He's like trying to shove a square peg in a round hole, but they want everything to match, to be easy to manage. The problem is that's not reality for most people. It's not reality for most businesses. So do what's right for your business. Make sure you're following these rules. And again, if you have questions, give us a call, 520-485-7371. Our website is guardiantaxlaw.com. And this is something where there's a wealth of information online, different videos. Again, 1099 versus W-2. There's all kinds of information out there. And it's easy to look up, easy to study. There's been plenty of seminars. Make sure you're getting recent information, though. Like I said, this latest change from the Biden administration only happened in January, where the regulation was put out. So follow the latest rules. Make sure you've got updated information, and you'll be fine. So again, I hope everybody has a great weekend. We're still going to be following up on the news and keeping you updated. Again, we still have, in a couple of weeks, another budget deadline coming up. But again, there are definite issues out there that businesses need to address. And as these come up, we're going to be focusing more and more on helping you as taxpayers and businesses navigate the IRS. And next week we're going to be walking you through. One of my goals is to have you actually walk you through some of the details of dealing with the IRS, getting cases done, and filing for appeals. So I mentioned, on that last case, if you have these penalties that you can appeal them, that you can use this section to appeal them. Ideally, most people want to focus on what they're doing. They don't want to read these sections. They don't want to learn about IRS rules and regulations and how to do these kinds of things. But it is handy to be informed or have someone in your pocket that is their specialty. So it always pays to ask questions first. The metaphor I use is, give us a call. We do free consultations. I'd much rather you get some free advice than step in a bear trap. And we see people where that happens to them regularly, where they get hurt bad because they didn't get advice first. So last takeaway here on the State of the Union. I know a lot of businesses are hurting out there. And this is just from my personal experience. This isn't political. I know a lot of people are struggling with inflation. One of the biggest increases that the government isn't considering and their inflation numbers is housing and utilities. It's gone through the roof. I don't know where you are, but I don't think it matters where you are. Housing costs have gone up dramatically in the last few years. There's been a lot of upheaval in the market, and that affects individuals. So if you are struggling, if you're having a difficult time, there is relief out there. And so call, get that free advice, get steered in the right direction. And I'd much rather spend some time giving someone some free advice than have someone get hurt and their business get hurt. So again, you could always reach out to us through guardiantaxlaw.com. Call us at 520-485-7371 or go to the smc.tv or smartmoneyculture.tv. And you have that opportunity button in the top right corner. You can click on that and reach out to us. And if you want to appear on the show, or if you want to talk, get in touch directly with me or another tax attorney, we can always make that happen as well. So only a couple minutes left. And make sure, I'm just going to put my plug in for here, make sure that you are getting your tax returns done. Make sure that you're paying those estimated tax payments. If you're self-employed at all, make sure you're having enough withheld from your taxes or your W-2 wages for next year, so you don't owe again owe next year. And if you have any questions about that, get that straight out, because now's the time to do it. Now's the time to get your bookkeeping done, stay on top of your bookkeeping, and do all those good habits. I compared it the other day to going to the dentist office. And do we do everything the dentist recommends? No, we should. Or you go to the doctor and he tells you do A, B, and C. And we're like, okay, well, I'm going to do A and D, but the other things, probably not. Doesn't match with my lifestyle or whatever, too difficult. But again, for your financial health, make sure you're on top of your taxes. Do that extension if needed. The biggest penalty is failure to file timely, and it's very easy to do an extension. You can just go online, do it. The extension form is very simple, and get that submitted to the IRS, and that will save you from the nastiest penalty, the worst penalty, which is failure to file timely, and then make sure you get it done by October 15th. Right? There's very little reason not to file, and if you do owe, the penalties will be a lot less. And I almost never advise someone, there might be a rare circumstance, but very rare, almost never advise someone to not file timely. So again, talk to a tax professional. There are still some available out there. I know good tax professionals that do have time available, but they're getting filled up fast. So have a great weekend, and we will continue the conversation next Monday on how to help you make taxes easy.